You're listening to Dental Student Vibes. So this is part 2 of our interview with Shane Kamkari. He's an attorney, experienced attorney for medical professionals. And Shane is very experienced in dental and medical practice acquisitions and mergers. He's really given us a lot of useful information. So be sure to hit us up on Instagram at dental.student.vibes for any questions, comments you guys have. And be sure to hit us up on Facebook and Twitter as well. We love to hear from you guys. Again, thanks for listening. We appreciate you always sticking with us and learning as we learn. So thank you guys. Here's part 2, and we're just going to hop right into it.
I would not be a self-respecting attorney if I did not give you guys a disclaimer. Just wanted to let you know that I am licensed to practice law in the state of Maryland as well as Washington, D.C. I am on inactive status in the state of California. That may soon change.
Okay, so I know when you're purchasing a practice, there's a couple of things that might go over your head that you might not consider. And when you're looking at purchasing a practice, has there been instances where someone will buy a practice and then maybe 10 years, 15 years down the line, they have an issue with like the foundation of the building? So is it important to get the building inspected prior to purchasing the practice?
Well, when you're purchasing the practice, you're not necessarily purchasing the real estate. So you may be purchasing a practice that is on a lease. So they lease a condominium, the dentist leases a condominium, starts a practice. A few years down the road, he wants to sell the practice. And then as one of the contingencies, you have the financing contingency to make sure that the buyer can get the funds and the loan that he or she needs to buy the practice. There are a number of other contingencies that come up, and transferring the lease and the landlord approving the transfer of the lease from the selling dentist to the buying dentist is another one of those contingencies that come up. But if you are buying the property, yes, there are feasibility issues, there are environmental studies that need to be done for these practices, but that is not going to protect you 10 years down the road. Okay. I mean, if there's something majorly wrong with the foundation, that may come up, but a lot of other issues don't really come up, and there is normal wear and tear. Obviously, that doesn't destroy the foundation.
Right.
But I did want to make the distinction that not just because you're buying the practice doesn't mean that you're buying the real estate with it. But if you are buying the real estate, then that's almost like 2 different transactions, because you're buying the practice and you're buying the real estate, and they are each going to have different contingencies. And then there's going to be a contingency that relates the purchase of the real estate with the purchase of the practice, because you do not want to buy one without the other if the selling doctor owns the real estate as well.
Right. Okay. So how common is it to get into that situation? Like, would people normally just buy the 2 of them, or are you more likely to just be buying the practice?
It really runs the gamut. I mean, it depends on the financial situation and ability of the buyer. I know nowadays students get graduated and they are saddled with, huge student loans and stuff. Yeah. So it becomes an issue if you're buying a practice for, $600,000-$700,000, but you also have to dish out another $600,000-$700,000 to buy the condo. Right. And they may not approve you for the loan because you have plenty of other loans, student loans and stuff. So it really depends on the ability of the buyer. Obviously, it's recommended if you buy the real estate with it, if you can, because you're not at the mercy of a landlord that could mess with you, a landlord who may decide to sell the building and yours is going along with it.
So you would have to move out if that was the case. Is that correct? Or?
Well, that's why you want to have an attorney negotiate the lease for you. It depends on what's in the lease.
Right. Okay.
So yes, and you may, if you don't have a good attorney negotiating the lease for you, you may spend, hundreds of thousands of dollars in building out the space. So you have a nice, suitable space for your dental practice. And then 2 years later, the landlord says, I'm selling the building. And guess what? It's somebody like Amazon or somebody else that wants to come in and destroy the entire building because they want to set something else up. And you have to get the heck out of there. So that is not a good situation to be in, because you lose hundreds of thousands of dollars just like that.
Okay. And also, just to throw this in there, I was reading the other day, so you can, if you own the real estate as well, you can charge yourself rent. If you own the real estate, you can have the practice pay rent to yourself. Is that correct?
Yes, exactly. Because the tax laws between how you pay taxes on income from real estate is lower than personal income taxes.
Okay.
So what happens is that even though you own the real estate and you own the practice, you sign a lease between the company or the business entity that owns your practice and the company or yourself that owns the real estate.
Right.
And that way, it's very legitimately you are reducing your tax liability, because you're lowering the income for which you're paying a higher percentage in income taxes, and transferring that to the real estate company that pays interest or pays taxes at a lower interest. So yes, that is absolutely something is done every day.
Okay, so it's probably a better idea to have a company own the real estate and a company obviously own your practice rather than the individual dentist.
Of course, I mean, yes, and because you have the issues of liability by incorporating or forming a business entity that minimizes your personal liability, you also get the benefits of that, minimized personal liability as well. So you certainly want to have form a business entity. Now, whether it's going to be a LLC or a corporation, what have you, take
Right.
your pick. But you find a suitable business entity for what you want to do, and you can have two different business entities, one for real estate and one for your practice.
Okay, so let's get into that a little bit. I understand a lot of dentists form just the S Corp for their dental practice. Is that usually the best route to go down, or would it be the LLC? How about for a new dentist purchasing the practice to establish his dental practice? Which way would you go?
Well, this is one of those things that is kind of state specific, because different states have different laws about what are the limitations of liability on an LLC, or in what cases you may run afoul of the laws for corporations and LLCs and subject yourself to personal liability. But generally speaking, they are pretty much the same. LLC is a new animal, and when I say new in law, 35 years, 40 years is new.
Right. Okay.
It's a new animal that they created that essentially limits your liability just like a corporation does, but you don't have to follow all of the formalities that a corporation has to follow every year. So it becomes it's less maintenance to have an LLC, but it offers you the same level of protection as a company could do.
Okay, so you usually wouldn't want to do like a C corporation then, at least not for like
the corporation. You do the same. The S corporation is an election on how you're going to be taxed. So yes, a C corporation C stands for closed corporation. They do that in cases where there's a family, but the problem with a C corporation is that you're looking at double taxation, because the corporation is a separate entity, and that C corporation is going to get taxed on its income, and when it pays dividends to its shareholders, then those shareholders have to turn around and pay a tax on it too. So for that reason, they form a corporation, but for tax purposes, they elect to be S corporation, and that pretty much works like an LLC, that it runs through, the income runs through the company directly to you, so you only pay taxes once.
Okay, all right, that makes a lot of sense.
I hope so.
So I know we've been discussing, like buying and selling practices. Another common route for a lot of new graduates coming out of dental school is going into a practice and being an associate, or maybe working for a DSO. I know there's quite a lot of different things that you have to keep in mind when you're signing a contract. Is there a couple things that we should be mindful, maybe like a checklist of things we should know beforehand?
What type of contract are you talking about?
When we sign as an associate
Right.
in a practice.
Like a DSO.
That's going to be either, with a DSO or a private practice. So.
Yeah, make sure that the person that's hiring you is not going to eat your lunch.
Because that's what we've seen. Because with a lot of the DSOs, you really have to be careful with what you're signing, because there's things like the non-compete clauses, and then you might have what was the other one that we discussed with the radius?
Well, you
Non-solicitation.
Radius.
Yeah.
Forget the name.
Are you talking about a non-solicitation?
Yeah,
Non-solicitation,
non-solicitation. Yeah. So what should the new dentist look for when signing an associate contract?
Well, you got to think long and hard about whether you want to be an associate to begin with, because yes, just about any dentist that gives you a job and a contract is going to have a non-compete and even a stronger non-solicit. Do you know the differences between a non-compete and a non-solicit?
We actually just
that
recorded an episode on this.
I'm glad you brought that up, because we did discuss the non-solicitation agreement on one of our episodes, and something that I wanted to get a bit of clarification on was the non-solicitation. So from my understanding, you can't take a patient from the practice that you're working at as an associate and bring them into your own practice. Say you purchase one later on down the line, and then on top of that, you also can't do that with the employers. Is that correct?
That's right, and non-solicitation could be done in a number of different ways. You can imagine that if you are an associate and you get your hands on a database of patients, and once you no longer work there, you're not going to solicit them directly as you would if you were working there. I mean, it's one thing to have the patient come in and you are working on them as an associate and say, by the way, I'm not going to be working here from next month, and this is where my offices are going to be, or I'm more than happy to offer you services there, or I can offer you a more affordable service, what have you. That's a direct solicitation of the patient of the practice for which you work for. But you can quit the job, and afterwards, if you have the database, you can send a similar letter that you were mentioning about. If you are buying a practice, you would send out a letter. You could do the same thing. If you have the patient's information, you can send out letters and contact them and say, oh, I'm no longer working there, and this is my practice. Why don't you come here?
So you can do that.
Well, not if it's in the contract that you cannot do that.
Right.
So that's why, I mean, it's fair to the person who is hiring you. But what I was saying is that you guys need to be mindful at the very outset about, do you see opening up a practice in your future, or you don't want to deal with the business aspects of running a practice, and you will be happy just going to work, working as an associate, bringing home some 120, 30 grand a year, and that's that. You're not worried about opening a practice, because if you are, then you have to consider the non-compete and non-solicitation and the limitation that is going to place on you once you want to start your own practice. Now, non-competes are not favored in law, in that essentially, because we are a capitalistic society, we want everybody to go out there, give it their best shot, compete, and be successful and be an entrepreneur.
Okay.
So they are not really favored. So if you, for example, if you say, if I put a non-compete clause in the associate employment contract that says once you stop working here, you cannot work within a 20-mile radius here, and you cannot compete with me. No court is going to uphold that.
Oh, really?
So,
okay.
yeah. So if you're smart, you know the hiring dentist who know the limits. Hopefully, they've talked to an attorney, and the attorney knows it. They would limit it to maybe a 5-mile radius, 5-mile, you know, and which is still pretty significant. I mean.
It is, yeah.
Yeah, I mean, imagine a 5-mile radius. That's pretty large. If you think about geographical area where you're not going to be able to set up your practice because probably most of your connections are within that 5-mile radius. That's where you work. Probably you live close to it. Everybody you know, your contacts, network connections, everybody else is by and large, within that 5-mile radius. Or if it's within a 10-mile radius, you've already cut out half of it. So that's what I was getting at when I said at the very outset, you should really try to decide whether you want to go into your practice for yourself and take it on from the get-go, or you would rather become an associate. Now, that is not to say just because you work as an associate doesn't mean that you're not going to be able to start your practice. But you're gonna set some limitations on yourself, and you should be mindful of that when you do it.
Right. I think most of us here, actually all of us here, I know for a fact, we all kind of see ourselves maybe go for a year or so as an associate to get our hand skills up. I don't think. See, that was the other problem with what you were saying earlier. Is coming out of school, I'm personally gonna have like $400,000 to $500,000 in loans, student loans, but yeah, the bank isn't going to give me how much money would they actually give me? You know, I would have to have some sort of liquid assets built up first, I guess, from that year of associateship, so that they'll approve a loan. And then even as you said, I would have to probably have even more assets available to purchase the real estate as well.
I mean, everybody's situation is different. You may have a co-signer, you may have rich parents, a lot of different things could happen for you to get the loan. The loan that you're getting for the practice, the bank looks at the tax returns and everything else, and they know that you're buying a business. So this is not something that you're gonna buy and let it sit in the corner of your living room, and
Yeah.
every month you're just dishing out money for nothing. You are borrowing that money and making monthly installments on it, but you're gonna be making money off of it. So it's a little bit different than, borrowing money and getting a loan to buy a car or buy a house.
Right. Okay.
Because those items are not going to generate any income for you. This, you are borrowing in order to go out there and make money. So it's a little bit easier, and you don't necessarily have to have collateral or assets sitting around for the amount that you want to borrow. But obviously, it does help if you have a co-signer, if you do have a house that you can use as a collateral. So one thing perhaps that you want to look into is talking to loan officers and
Okay.
an attorney that has been in practice and is experienced. They can put you in touch with a loan officer. They can put you in touch with a contractor that if you just want to start up your own practice, that is going to be less costly. So that's another option that you may want to look into. So instead of paying $600,000-$700,000 to buy a practice, you spend about $300,000 to build out your own practice, start your own practice with brand new dental equipment and everything else.
Right.
And you have some money left over for marketing. You get credentialed by different insurance companies, and within a matter of months, at least you get those insurance patients. In the meantime, you work on your marketing to bring in patients that are going to pay out of pocket, and then you can change the percentages of those patients if you're not happy doing insurance work.
Right.
So that's another option. Or you can talk to loan officers and see what you qualify for, what you don't qualify for, and you get a good handle on the type of practice that you can go after and the purchase price that you can afford.
Right. Awesome stuff. And another thing about the new associate, the new grad. So give me sort of like a timeline. Let's say most new grads graduate in May, and I guess they interview in October of that previous year.
Yeah,
right?
that's what we've heard most commonly.
A few months,
Right.
licensing and everything.
Right. So when would you get so let's say you go in for your interview October 1st. When do you usually need to get that contract to the lawyer by to review it? What's the timeline for that until you agree to that position?
Well, I mean, when they make you the offer, they send you a letter and say, this is the offer, these are the terms, and then you take it to an attorney and have it looked at.
Okay.
Did I get the question right?
Simple as that. Yeah.
Okay.
Simple as that.
Yeah. Well, as soon as you get it, I mean, the person that wants to hire you probably wants to hear within a couple of weeks, maybe a month, so they know whether they hired somebody or they should still be looking. So I wouldn't be surprised if they even put a deadline on it sometimes.
Right.
It does happen.
So for that new grad coming right out of school, I guess just as we spoke about in the previous episode, you go ahead, you just Google, find a healthcare attorney or somebody who's dealt with, I guess you could say, just healthcare law, dental law, and you would go and you would find. Also, how much would they charge? Is there usually a fee associated with that?
Well, I mean, it depends on the service. Some work that we do, we can give you or we can come up with an estimate of how much time it's going to take, and then based on that, we could give you a flat fee. But that's not very often, especially if you're dealing with somebody else. So it would be one thing for me to say that I can negotiate a lease for you. And I can estimate like how much time it's going to take, but sometimes that doesn't even work because you're working with a landlord. That may be very difficult. Right. But especially if you're buying a practice and you're dealing with a seller and their agent, and things come up, and with regard to the contingencies, due diligence, you don't know what's going to come up, how long it's going to take. So because of that, we usually charge based on hourly rates. And it could be that you send a letter of intent and then you get a kick-ass offer and you decide, hey, I can't pass this up and I'm not even going to buy the practice.
Yeah.
So you call me and then we stop working, and if we charge you based on hourly rates, then that's your bill. As opposed to if I give you a flat fee, then you're going to have to pay the flat fee, and it's too bad that you change your mind.
Yeah.
So somebody's going to be unhappy.
Right. So
because of that, we usually do it based on hourly rates.
Right. So you could, let's say I just get like 5 interviews, a bunch of places. I could just give them all to you and you would take a look at all of them and you would be able to tell me which one honestly just looks like the better deal, or here's something that's a red flag, something like that.
No, I think if you came to me with 4 different offers, I would say, look at the compensation, look at the location, look at the people that you're going to be working with, look at your boss to be. Do you know any of them? And which one do you really feel comfortable? Like, which job do you want to go for? There is really no point negotiating 4 different contracts when you're paying an attorney. So you should really narrow it down to, I would say 1, and say, take the job based on the compensation and based on the other things that you are considering that's important to you individually and personally, and narrow it down, and then have the attorney review the contracts for legal work. Again, like going over an associate employment contract, that is something that we could work with a flat fee, because it is not a never-ending story of you don't know what's going to come up in terms of contingencies and what you're going to run into. You have a contract, you may want to tweak a couple of parts here and there with the non-compete, with the non-solicit,
right,
with who pays the lab fees, who's responsible for continuing education, who's going to pay for it, and or how much of a notice do you get before employment is terminated, and you give that to the person that wants to hire you, and then they probably go through it, and maybe they would accept none of them, maybe they would accept all of them, or maybe they would say no to a few and yes to a few, and that's that. You can't really twist their arm.
Okay.
To
So
hire
speaking of that,
the terms that you want.
right. So speaking of that, are there any sort of red flags that you would kind of look out for? In your experience, have you ever seen any in the contract, or anything that would, kind of worry the new associate? Or is it just kind of like it doesn't happen?
It's really, really different because the spectrum runs from a nice doctor having an intelligent attorney to a crazy dentist that has a crazy lawyer. So if you tell me which one, I can tell you too. But no, I mean, usually, red flags would be, again, about the non-compete, non-solicit. Sometimes they put in, you got to pay the lab fee. Sometimes they say, you got to pay for the continuing education. Sometimes they say, you got to pay for the transportations. And so one thing that comes up is that they want you to do some marketing work for them.
Really?
Yeah, it comes up quite often.
Commercials
So
here.
have like 10 different events and go to things and show your face, but there's really no compensation. So you want to put a limit on that because you don't want to work, 8-9 hours at the office and then have to do 3-4 hours a day, 3 days a week.
That's wild. I've never heard of that.
You're like an athlete over here.
Well, that's an example of a crazy dentist having a crazy attorney.
Yeah.
Got to discuss endorsements at that point.
Yeah.
Precisely. One other issue that I wanted to touch on regarding buying of practices. So when you go buy a practice, let's say that the seller has formed a business entity and now they want to sell the practice. There are two ways to go about this. You can, let's say it's a corporation, you can buy the stocks of that corporation, and the corporation remains the same essentially, and you become the owner of the old corporation. The problem with that is that business entity that you just purchased has been in business for a while, and there could be a lot of liabilities out there against that corporation that you just own.
Okay.
That you just purchased.
Right.
And all of those liabilities are going to stay with that corporation that you now own. And guess who is going to be liable for it? Essentially you.
Right.
I mean, the corporation is going to be liable, but who owns the corporation? You do.
Yeah.
So because of that one factor, there are pros and cons in buying the assets of a corporation versus the stocks of the corporation. So the first example that I was just discussing is where you buy the shares or the stocks of the corporation. So the corporation remains the same. It's just the owner of the corporations that changes hand. The other option is that that corporation owns all of the assets that are in that practice, the operatories, the desks, the furniture, anything and everything else. Maybe they own a car.
Right.
So instead of buying the stocks of the corporation, you buy the assets so that you form your own corporation or your own LLC, and your company, whether it's a LLC or a corporation, buys the assets of the old corporation. Now you have a completely new entity that doesn't have any histories, that doesn't have any unknown liabilities that you may not know about. And you don't have to worry about somebody coming back and suing you in 2.5 years out of the blue.
Right. That makes a lot of sense. Absolutely.
Right. So that's one of the most important things, that if you don't know, it's easier to do a stock purchase, because all you do is you sign the certificate and say, hey, I'm selling all of the stocks of the corporation to dentist B for buyer, and I'm out of here.
Right.
Your problem is that, and sometimes it could be a clever move by the seller, but you can imagine like the seller had an employee. That employee was fired 6 months ago. Now you're buying the company. Unbeknownst to the seller, the person that the person that you fired 6 months ago has an issue with being fired, and they think that you fired them because of some kind of a discrimination.
Okay.
So, but the seller doesn't even know. The seller is not notified. He doesn't know. But the statute of limitation, for example, in Maryland, is 3 years for most causes of action.
Oh, wow.
So that employee could come back, has 3 years to file a suit. Or let's say that your company has owns a car and you deliver stuff, and there's a car accident or something happens, but everybody walks away from it, nothing happens. They have 3 years to file a lawsuit, and guess what? Like the guy goes to his chiropractor or a physical therapist after 7-8 months. They take an x-ray, they see a problem with their back and say, oh, you didn't know this, but apparently this happened. And they want to come back and sue the employer because the accident happened during the course of business, during the course of employment. But the seller is gone. If the company remains the same, their cause of action is against the company, not necessarily the individual seller. But since you bought the company, you're on the hook for it.
Right. This is something we have never even thought about. So this is very good stuff to know here.
Excellent. So there are disadvantages to buying the assets, but that's just the final word on it. You cannot afford to buy the stocks of a company because it's just an unknown question. Nobody can give you any kind of guarantees about what happens or what happened in the past or who's going to go berserk. And even if their lawsuit is not successful, you're going to have to dish out tens of thousands of dollars to defend yourself in court.
Right.
Just not worth it.
Right. So is it ever common to split it? Like, would the selling dentist ever stay on? Like, would you ever go like 51-49 if you're doing the stock purchase, or is it the selling dentist usually just wants to get out completely?
No, you could be an associate, and then the person that hired you after a few years, they want to retire, and what better practice for you to buy than the practice that you've been working at?
Right.
You know the patients, you know the employees, you know the ins and outs of it. There are no surprises. So what happens is that you could buy into the practice because if you have an entrepreneurial employer, they figure that, hey, why don't you become a partner, and then we can open up another location and we can grow the pie and the gross revenues that way. And we have 2 locations, and we can exchange. You come here 2-3 days, I come here 2-3 days, and then we swap at the other place.
Right.
So that's one situation where an employer-employee relationship could, and when I say partnership, could turn into partnership. I'm putting partnership in quotes because you're talking about becoming a co-shareholder. Really, partnership has a different legal definition that doesn't give you protection against personal liability unless it's a limited liability partnership, in which case the limited partner has protection, but the general partner doesn't have any protection against personal liability. So that's one of the situations where you work together and you decide that you can expand together, and you say, well, I one day want to have my own practice. If you want to open up a second location, let's become partners. It could be that the employer decides to retire and you can buy the practice outright. And a number of other situations could come up where employer-employee relationship either turns into partnership, again in quotes, or where you buy the practice out from the retiring dentist.
Right. All right, Shane, I got to tell you, we are just
blown away.
Blown away.
Yeah. That's the best phrase to use right now.
I think you need to come teach a class at our school because this is so much wealth. You are a wealth of knowledge.
I appreciate that, and you guys are pretty smart. I'm very happy to be with Dental Student Vibes today, and you ask great questions. And I do often volunteer and go talk to dental students at dental schools to give them this information. The added benefit is that they get an introduction to us. But I've never been one of those attorneys that hung up a shingle just to make myself rich. I like the clients to get the benefits of it. And thankfully, I have thankful clients and ex-clients that always call back and are appreciative, and that means the world to me too.
Absolutely. Shane, where can our listeners find you on Instagram, Twitter, and website?
Website is they can look for counselfordoctors.com, and that's a mask name just to make it easier. They can also find us, it's the same website but with a different address, dentalmedicalattorney.com, dentalmedicalattorney, one word.com. On IG, we are on DDS_MD_attorney. And you have the website and Twitter. You can find me at Kamkari Law, which is it spells KAMKARILAW.com. I'm sorry, not .com, at Kamkari Law. Sorry.
All right, we will put all of these in the show notes. Shane, thank you so much for being with us today. And we're definitely going to have you on again. I know a lot of our listeners are going to have a ton of questions from this episode. Looking forward to doing another episode with you. So thanks a lot for being with us today here.
Thank you so much for your time, Shane.
I really enjoyed it chatting with you guys, and anytime other subjects come up, let me know, and I'm more than happy to join you guys and your audience.
Yes, sir.
Thanks, Shane. Take care.
Thank you.
Bye.
Take care, guys.
All right, that was part 2 of our interview with Shane Kamkari, an experienced attorney for dental and medical practice acquisitions and mergers. You can follow Shane on Instagram at DDS_MD_attorney. And of course, you can follow us, the Dental Student Vibers, on Instagram at dental.student.vibes. We're going to definitely have Shane on again. He gave us so much great information. As always, you guys are such an amazing audience, and we love all of your questions, comments. Thank you for listening. Peace out.